For document item number 1, WPC 41573 of 2020.
In view of the discussions, we find it imperative to clarify that, having regard to the principles enunciated by the Honorable Apex Court in a catena of decisions, there is nothing to quarrel that the High Court is not expected to act as an appellate court sitting in appeal over factual findings in a disciplinary proceeding, as the High Court's role is limited to reviewing the disciplinary proceeding. Such limitation, however, includes the jurisdiction to examine whether there have been errors of law or procedural lapses resulting in a miscarriage of justice, particularly when the authority has failed to consider relevant material touching upon the genesis of the allegations. The same is fortified by the apex court in the matter of Ramlal versus State of Orissa, State of Rajasthan. In essence, the court in judicial review can interfere when the findings in a disciplinary inquiry is vitiated by procedural or evidentiary lapses since the very inception to ensure adherence to the principle of natural justice. Therefore, keeping in view the principle of natural justice, this court finds that the inquiry proceeding against OP number 1 was marred by significant procedural irregularities and violations of the principle of natural justice. The denial of access to relevant documents essential for preparing a defense and the refusal to summon key witnesses capable of corroborating the defense claims deprived of OP number 1 of deprived OP number 1 of a meaningful opportunity to present his case and rebut the allegations effectively. Furthermore, the complainant's testimony, which formed the crux of the charges, was rife with contradictions, inconsistencies, and vagueness. It failed to provide a coherent and credible basis for attributing any wrongdoing to OP number 1, casting serious doubt on the legitimacy of the findings of the inquiry officer. Upon examining the case, it is evident that OP number 1 is governed by the Central Civil Services Classification Control and Appeal Rules 1965. These rules provide the framework for disciplinary proceedings, emphasizing procedural fairness and the principle of natural justice. Rule 29 of CCA Rules 1965 provides for revision of orders in disciplinary matters but doesn't extend to authorizing a de novo hearing or initiating fresh disciplinary proceedings. Moreover, considering the significant passage of time, that is more than 20 years since the proceedings were initiated, and the advanced age of OP number 1, that is 72 years, conducting a de novo hearing at this stage would neither be feasible nor serve the ends of justice. In light of these considerations, it was correctly held by the tribunal that the impugned order of punishment deserved to be quashed. In the result, in our considered opinion, the order of the learned tribunal warrants no interference. OP number 1 is hence entitled to the release of his current pension, arrears, and other retirement.
I agree.
Pardon to make a mention, my lord. One criminal appeal, the appellant is inside custody nearly about 10 years and never released on bail.
Pardon, Lordship. Mention, Lordship, in this matter, the petitioner has challenged the learned cat's order, which was on unreasonable grounds and has not taken into consideration this honorable court's judgment as well. It is a matter which was last listed on March 2023 and till date it has not come on board.
Pardon, Lordship. I have filed an IF for extension of interim bail loss.
Pardon, my lord.
Manner criminal appeal. Appellant is in custody manner more than 7 years manner.
Pardon, my lord. The surrender date of appellants 13/12/24 has been filed. I has been filed, my lord.
Extension of the.
My lord.
Please give it.
Pardon, the petition custody since 12 years, my lord.
Pardon to mention, my lords,
I pray for adjournment for item number 35. Since your honor's order was that another case should be tagged 24738. It has not been tagged, and also
The counsel, please wait when the matter reaches, make a mention. All right. Next.
Supplemented list. Item number 2.
Your Lordship, my lord, I am Richard Puri. It is a governor case, my lord, Narottama Ratha case, my lord. However, in the last occasion, your Lordship was pleased to pass an order making a direction to the petitioner to show any documents in regard to the petitioner's document was rejected by any settlement authority or officials. My lord. So, in this regard, please make a glance on 6/2024. I filed a document, my lord, with your Lordship, my lord, that is the Royal Reports, my lord. That is how sorry, Adosta reports.
Mr. Panigrai, probably our question was that which order is impugned in this writ petition?
My lord.
Whether that order has been filed.
No, my lord.
And
Sorry, my
then
lord.
we had asked for the order to be filed. Which order has been impugned in this?
My lord. Sorry, I may
What is
point out one in time, my lord.
Have you gone through the order which we passed on 3/12/2024?
My lord.
So please go through it and see that last paragraph.
My lord. I may permit my lord to read, and after the examination of the judgment, Lord of Counsel for the state submits that both the case of the petitioner is almost identical, but he draw the attention of this court to the grounds taken by the petitioner in the writ petition, wherein it is stated that the assistant settlement officer ignored the petitioner's document and the petitioner has a prima facie title and possession over the sum on hard plot 7,000 and subscribers.
So that was your ground that
Right.
whatever documents you have filed that
Was
has been ignored, and your documents can show that you have a prima facie title and you are in possession of the land in question.
Right.
So that is how we asked you that whether you produce all the relevant documents before the ASO or not for recording your name in the ROR. And number two, whether any order was passed in accepting such document or ignoring such document, as you have mentioned in your grounds in the writ petition. So,
Right.
and whether any specific order to that effect has been passed.
So,
So,
my lord, I have taken instruction to my plan. My lord, I want
you want for the time.
my lord, a week may be granted.
All right. The Learned Counsel for the good name is Learned Counsel
Panigrai.
Trilogian Panigrai. You are appearing from which
Puri.
Puri?
My lord.
Mr. Trilogian Panigrai, Learned Counsel, appears to virtual High Court Puri and submits that he may be given some further time to obtain instruction as per the order dated 3/12/2024. This matter in the week commencing from give a date. Yes.
Item 3.
Please. Here the end of the petitioner was
In fact, I am appearing for the opposite.
33 के bill.
Just a minute. So, you are supposed to file a consolidated writ petition after serving a copy on the State Council.
I've already filed.
You have filed. Mr. Naik, you have got that consolidated.
I haven't received it. Must be filed in the email.
Acha. And we also asked you to serve a copy on Mr. Tripathi.
Yes, I've
who
already.
is appearing for.
My lord, I have
You have
received.
received.
I am appearing today also.
You are appearing today.
Yes.
So, what do you propose to do?
Here, Lordship, see, here everything has been decided, my lord, because
What is your prayer in this
my
writ
prayer, my lord, a land of the petitioner.
consolidated writ petition the kind? Let us see your prayer.
Yes.
please come to page number 13.
Directions shall not be given to the petitioner OP number 3 and 4 to release compensation in terms of the order dated 13/1/2022 on Annexure 1, order dated 16/1/2023 on Annexure 6, and the letter dated such and such on Annexure 7 series within a stipulated time. OP number 1 and 2 shall not be directed to pay the compensation to the petitioner as per order number 6 and 7 series with interest and recover the same from OP number 3 and 4. But here,
So who are these opposite parties number 3 to 5?
TPCODL, my lord.
Okay.
TPD.
So in such type of cases, if you have not been disbursed with the compensation amount for any reason, so counter affidavit is necessary.
Well, my lord, here everything has been decided. They were party to the proceeding, my lord. Because earlier, my lord,
They have agreed to pay you compensation amount.
yes, my lord.
No.
Where is that?
Yes, my lord. Because, my
No,
lord,
you say yes.
yes, my lord.
Wrong.
My lord, against the order of the collector, my lord, they have approached this honorable court, page 26, my lord.
Page 26.
Yes, my lord. The collector has directed to pay compensation in terms of the 2013 Act, my lord.
Just a minute.
Yes. Page 26, relevant portion is
Yes.
page 27, my lord. This court
Part of
without
23, as
expressing any-
agreed by learned counsel.
My lord,
As agreed by learned counsel for the parties.
yes. Counsel, and without going through the records, this court, without expressing any opinion on the merit of the case, disposes the writ petition, directing the OP number 4 to consider the representation filed by the petitioners by Annexure 9 and pass appropriate order in accordance with law within a period of 4 weeks from the date of production of a certified copy. My lord, OP number 4 was Energy Department, my lord. Then your lordship may turn to Annexure 6, page 30, my lord. Relevant page is 31, madam. Paragraph 6, middle portion, hence.
This our order was passed on 22/11/2020. Annexure 4, you just placed
Yes.
it. So thereafter, on the basis of this order which was passed by us,
Yes.
this Annexure 6 was passed.
Yes.
Okay.
16/1/23.
Relevant page is 31, my lord. Paragraph 6, middle portion, hence.
Hence the CEO.
Yes. May I place, my lord?
Yes.
Hence, the CEO TPWDL is directed to take steps.
Para
to-
6, sir?
Yes, ma'am.
Para 6 or 4.
Middle.
Para 6 may be read from the beginning, your lordship.
Yes.
You read from the beginning.
Yes. Beginning, my lord. In compliance with
No, having regard.
Para 6.
Yes.
Para 6.
Having regard to the facts and circumstances indicated above, the undersigned finds no illegality or impropriety in the order passed by the collector Balangir. To reiterate, although the electrical substation installed over the land in question in an existing property of the government of Odisha, TPWDL, and used by TPWDL by virtue of the vesting order, there has not yet been acquisition of the land from the recorded owner as per the governing law. Hence, the CEO.
Mr. Mohanty, it is only after you keep mum, then only we can start. Let your conversation be over.
Yes.
Yes.
Please proceed.
TPWDL, by virtue of the vesting order, there has not yet been acquisition of the land from the recorded owner as per the governing law. Hence, the CEO TPWDL is directed to take steps to purchase, acquire the land in the name of the Department of Energy, Government of Odisha, from rightful recorded owner of the land with necessary approval from all concerned on payment of compensation as per the provision laid down in the Right to Fair Compensation Act 2013. The payment towards such compensation shall be governed under the respective vesting order of the commissioner. That is OERC, my lord.
Yes.
Then, my lord, your lordship may turn to page 33, my lord. 33, my lord. The committee was formed where the representative of TPWDL, like Deputy Manager Legal and Superintending Engineer TPWDL, along with Land Acquisition Collector, Land Acquisition Officer, all were party, my lord. The market value of the land was determined, my lord.
Yes.
Then, my lord, next page, your lordship may turn to page 34, my lord. The matter was placed before the District Compensation Advisory Committee. The lordship will find the name of serial number 5, Superintending Engineer TPW Electrical Circle, Balangir, my lord, on the top, my lord. Then, my lord, in that letter, my lord, the compensation was determined.
Where?
Next page, my lord.
35.
Compensation was determined.
35.
Page 35, my lord.
2 crore 18 lakh.
My lord.
2 crore 18 lakh
Yes,
7,000.
Name of the RT is Dhruv petitioner.
Yes.
Allah. SC so and so, plot number so and so. Okay. So it is 2 crores.
2 crore 18 lakh 7,000. No, 21 lakh 87,000. 21 lakh 87,000.
Yes.
No, man.
2 crores 18 lakh.
2 crores 18 lakhs 70,000.
ନା 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 ଆଉ ଗୋଟେ ଛାଡି ଯାଇଛି କି ନା ନା ଶୂନ ନାହିଁ 21 lakh 87,000.
ଆପଣ ଏଠି
Proposed rate per acre.
1 crore.
ଓ ଆଉ ଏପଟେ ରହିଛି ଆଚ୍ଛା
Page 33 ରେ ଅଛି.
ଆଚ୍ଛା
Page 33.
ଏଠି
That is 1
ରହିଛି
crore
1 crore 8 lakhs.
4 lakh. 1 crore 4 lakh 73,105.
Then ମିଶିକି ରହିବା ଅଛି 1 crore 8 lakhs 92,029.
Okay.
Oh.
That's it.
whatever.
Here, my lord, they were party, my lord. And thereafter, my lord, page 56. Sorry, page 36, my lord. Annexure 8. The land acquisition pursuant to this decision of the committee, my lord, the land acquisition officer issued a letter to the TPWDL to deposit 2% of the contingent amount for purchasing the land, my lord.
Yes.
To a stamp duty, my lord. So my annexure 6 was passed pursuant to the direction of this honorable court. They have come to this honorable court. They have not challenged this, and thereafter they have participated in fixing the market rate. They have participated in the determination of the compensation amount, and thereafter, my lord, when 2% deposit was made, my lord, direction was made. They are not acted upon.
They are not.
They are not depositing the same, my lord. When we approached them, they said that within 15 days it will be given.
Yes, Mr. Counsel.
My lord, I be permitted to place the, so far the annexure 6 is concerned, we have filed an application before the Energy Department for reconsideration of that order. I am filing this same in shape of affidavit, your lordship.
No, you thereafter you participated
My lord,
in the member of a committee as that.
My lord. I am placing matter, your lordship.
Yeah.
Initially, your lordship kindly glance to page 5 in a sequence manner, your lordship. Page 5 of the writ petition. Initially, the petitioner moved to this honorable court by filing a writ petition double piece number 1827 of 2010, where your lordship kindly glance.
No, what has been done earlier, it's leave it. Now the thing remains that after the latest order was passed, as it appears that
16 January 2023
to be formed, and this committee, you were a party, and you decided that what should be the amount to be paid to the petitioner, and accordingly the direction was issued by the land acquisition officer to the superintending engineer that you deposit this much of amount. So that you have not done as yet.
That has not been done. For the sake I am submitting, lordship, the Energy Department has issued a notification in 2009 that whatever land that has been acquired.
So why did you agree then? Why did you agree in Annexure 7 series?
That is
you were a party. You agreed that this much of amount is to be paid to the petitioner.
For
and
which
now you are backing out.
For which we have filed an application before I have submitted in shape of affidavit.
No, but that is of no use. Why to approbate and reprobate at the same time? Having agreed for that, how can you?
No, we are a party to the same. We are party to
no point, we cannot go beyond that again. Once you have come out and you become a party to the decision of the compensation amount, how can you back out right now, even if there is a matter pending?
No, we have only filed an application for review or reconsideration of this order, Annexure 6, before the Energy Department on 4/11/2024. That is pending with the Energy Department.
4/11?
If you yes, if your lordship direct that Energy Department take a decision, whatever decision take
Comply that order. Otherwise, we will ask the personal appearance of this man. with the superintending engineer. We are keeping this matter pending. The writ petition has been filed by the petitioner, Dhruvacharan Kumbhar, with a prayer. Take down this prayer. The learned counsel for the petitioner submitted that earlier the petitioner approached this court in WPC number 27355 of 2022. And this court by order dated 22/11/2022.
Opposite party file. TPWDL
Acha,
file.
opposite party number 5 na kete?
Yes.
Opposite party no. And this court by order dated 22/11/2022 dispose of the writ petition with a direction to the opposite party number 4 mane kiye thila ta dere?
Number 4
Executive engineer or what?
4 number পক্ষে তাদের কিয়ে ଥିଲେ?
ଦେଇଛେ ସେଟା ଇଏ
Department of Energy, Government of Orissa.
4 number পক্ষে ଥିଲେ Department of Energy, Government of Orissa, ঠিক। To consider the representation filed by the
TPWD.
opposite party number এটি কে?
There are for 4 petitioners. The TPWD, executive engineer.
By the petitioners in that WPC ନା ଦେଖିଦେବେ ସେଟା ନାଁ ଅଛି ଆପଣଙ୍କର page 24 ରେ ନାଁ ଅଛି କୋଉମାନେ ଥିଲେ petitioners ହେଲା page 24 cost title ଅଛି
here OP number 1
and to pass appropriate order in accordance with law. In pursuance of this order passed by this court, it appears that the government
Department of Energy
of Odisha Energy Department by order dated for 16th January 2023 found that there is no illegality or impropriety in the order passed by the collector Balangir and accordingly directed the CEO TPWDL to take steps for purchase oblique acquire the land in the name of Department of Energy, Government of Odisha from all the rightful oblique recorded owner of the land with necessary approval from all concerned, on payment of compensation as per the provisions laid down in the right to fair compensation and transparency of Land Acquisition and Rehabilitation and Resettlement Act 2013. And the payment towards such compensation shall be governed under the respective vesting order of the Commission, bracketary OERC. It further appears that a committee was formed, which is called District Compensation Advisory Committee, and Additional District Magistrate Balangir, Sub-Collector Patnagar, DFO Balangir, Tahsildar Khaprakol, Superintending Engineer TPWDL Electrical Circle, Balangir, Sub-Register Patnagar, and Land Acquisition Officer Balangir, were the members of the committee. 34 Annexure 7. And accordingly, the market value of the land was determined. In pursuance of such decision taken, the Land Acquisition Officer, Collector Balangir, that is opposite party number so and so, by later dated 29/8/2024, addressed to Superintending Engineer TPWDL Electrical Circle Balangir, bracket opposite party number so and so, requested to deposit 2% of the contingent amount worth of rupees 2,09,462 in favor of the Land Acquisition Officer Collectorate Balangir at the earliest through account pay check. it is the contention of the land council for the petitioner that such amount has not yet been deposited, for which the no progress should be made. After hearing the land and council for the respective parties, so also including the land council for the TPWODL, we direct the opposite party number. With that opposite party?
4 and 5.
4 and no 3 and
5.
4.
5.
The consolidated it. Consolidated 4 and 5, no?
4 and 5.
4 and 5 to make the necessary deposit within a week. Matter be placed in the on 23rd December 2024. The land and council for the opposite party number 4 and 5 shall produce necessary document showing the compliance of this order. Yes, next.
My affidavit may be taken in recording also.
Land council for the opposite party number so and so files an affidavit which is taken on record. Let the copy of the affidavit be served on the land council for the petitioner. So also the land council for the state. Yes.
Item 4.
Item 4.
I'm for the opposite party.
My lord, item 4, we need required to file an additional affidavit. Some facts are required to be enlightened in the court, which was not brought to the notice. So, by way of affidavit by next date, we will file. Let's give it 10 days time. In the meanwhile, we will file. Where the petitioner? You know the petitioner.
And you were asked to find out any rule to that.
Yes, yes. Let's see direct seats. Yes, yes. Both the things were highlighted to the court next date.
Okay, Mr. P.K. Pari, Land Deputy Solicitor General of India, and Mr. Deepak Gochayat, Land Central Government Council, submits that the matter may be taken up on some other day to take necessary instruction in the matter and file an additional affidavit. That is the order? Okay, put up this matter on such and such day. Yes, no. The land and council for the opposite party is present.
Item 5.
Item 5 may kindly be taken up tomorrow
Okay.
for the petitioner.
Request submission is made on behalf of so and so to take up this matter tomorrow. Leave this matter on 11th of December 20. Yes.
My appearance opinion of
The Deputy Solicitor General, आपण दे दीजिए ना ठीक है ना सु आगुर दे
Item 6.
May please. In this rate petition, the petitioner has challenged the order passed by
use the mic properly.
the petitioner has challenged the order passed by the Lawrence Central Administrative Tribunal, Cuttack Bench, Cuttack, as he has not get any notice at the for appearance before the tribunal while the final adjudication order has been passed by law. And
No, you are challenging the order dated 4/1/2024.
My lord.
That is annexure
6. My lord.
And also who filed that RA review application?
That opposite party.
Okay, that order went against them or what?
In their favor.
Absence. It was an ex parte order with that.
That is ex parte order.
Okay, no. Why they filed the review application?
I do not know why they filed review application because I am not the party. How can I say?
Okay, let us see that annexure 6.
Well, in the entire order sheet,
no, just a minute. You are the respondent or you are the applicant?
I am the respondent. I may be respondent, but I am not implicated as a party.
No, you are not implicated as party.
My lord.
What is the prayer made by the that applicant Karthik Sahoo?
They made prayer that the promotion has been granted to Mr. Arun Kumar Kundu, opposite party number 5, is not correct one.
Opposite party number 5. You are that person.
I am not that person.
Then how you are affected?
That and that's I do not know, because I came aware about the fact when the department has issued a notice to me that your promotion is going to be not correct, basing on the judgment passed by the Honorable Tribunal.
So that means you have been affected by virtue of this
Order, my lord.
judgment which has been passed by the original by this Central Administrative
My
Tribunal.
lord.
Where is that you say that you received some kind of
That is page.
The question before us
Page
the other day
118.
was the question before us the other day was that your appointment was subject to the result of this writ OA.
My lord.
That was the appointment order. On that you were to say.
Is it not correct that your appointment in the appointment order, it has been mentioned that an original application is sub judice before the Central Administrative Tribunal, and your promotion or whatever it may be would be subject to the result of that case?
That has mentioned in my promotion order.
Yes.
But
so
so
why didn't you take
that,
steps in filing an application for impleading you as a party before the Central?
my lord, your lordship kindly visualize the review application, page 116, when it has been filed, and he has filed to make me party. But how can I file a case before the court? So I may be treated
Then
as
you
party.
have to accept
For
the
what?
result. Then you have to accept the result.
My lord,
If your
when
promotion is
my
subject
name
to
has
the
not
result of a proceeding and you did not try to implead yourself in that proceeding, remained silent, then it would be subject to the result that have been rightly done.
my lord,
Whether
that
you
is,
have party or not, that's
my
a
lord,
different matter.
my lord, we are
It is
here.
not that you are kept in total darkness.
My lord, we are here challenge the order which is passed by the tribunal is divorce the procedure adopted by the CAT when somebody has filed a case against somebody. Department has to issue notice to the person who was going to be affected. The tribunal has not done so.
It is tribunal's duty.
Yes, that is rule is like this.
Kindly read.
Yes. That I have given a written note of submission, my lord.
No, that will come later.
Yes.
Firstly, you see.
Rule 11 of the
Take it
CAT
on it.
procedure rule.
Just a minute.
Service of a notice.
Please, there was an instruction that whichever act, rule, or decision you intend to rely upon, you are to give the court master advance intimation about that so that he can make that rule ready, so that there would not be the time of valuable time of the court would not be consumed.
My lord, I am giving short notes, my lord, where I mention everything.
The counsel, you are placing a rule and you are just now telling that this is the rule.
The rule
Now
is
he
also
would say
placed
that
there.
he is now searching for
The
that.
rule is in that written note, short notes.
Where is that?
That is page number 2.
Where is that? We don't have that.
It is mentioned in the list. It is the top of the list. Top of the brief.
bar 24.
My lord.
What you have mentioned there?
That is page number 2. Rule 11 of a CAT procedure rule provides service of a notice by registered post with acknowledgement due, but no such notice was received by the petitioner from the learned tribunal. Then Rule 30 of the CAT rules provides that the judicial bench of the registry shall record in the column in the order sheet notes of the registry the details regarding completion of a service of a notice on the respondents, such as date of issue of notice, date of service, date of return of notice, if unserved steps taken for issuing fresh notice, and a date of completion of service of notice. Then Rule 38 of CAT rules provides that if the pleadings are complete or if the case is deemed to be ready for hearing, the registrar shall record the same in the order sheet and order for inclusion of the list of cases ready for final hearing. So these procedures has not been followed by the tribunal.
Should have mentioned it, but should have given the advance intimation that you perform kind of short marriage.
CAT rule is with
Who is your authority?
It's relevant.
Railway means
The
opposite
general
party
manager,
number. No,
general
here
manager.
in this writ petition, they are opposite parties number 1, 2, 3, 4, 5.
No,
These are the
2, 3, 4, 5.
okay 2, 3, 4, 5. So for railways, who is appearing, Mr.
We are appearing. My
Acha,
lord, we are
Mr.
appearing.
Mr. Padi, one thing we just want to ask you
My
that
lord.
while issuing the order in favor of this petitioner, that appointment letter, you have mentioned that it would be subject to the result of this original application, which is sub judice before the CAT,
Tribunal.
right?
Yes, ma'am. Yes, ma'am.
So when the matter was going on before the Central Administrative Tribunal, whether it was not necessary on your part to bring it to the notice of the Learning Tribunal that there are some other persons who are likely to be affected and they should also be given an opportunity of hearing because we have issued the appointment order in their favor in which it is mentioned that it would be subject to the result of the this application. So is it not your duty also to bring it to the notice of the court?
Lordship is correct. Yes. Yes. Well, that part will take instruction, my lord.
No. Instruction how, where, when you will take, and from whom you will take. But where is that? You have
If
the
actually,
where is the provision that the CAT is responsible for this issuing notice? Where is that in the rule?
Because CAT was not made aware. Just
Court-
keep in mind, CAT was not made aware that X has been issued with an appointment letter in which such type of condition was there.
And when the judicial process is going on, when their opposite party, they have already been stated in they have not appeared.
Yes.
When they have not got notice, how they can appear?
No.
We are not taking, we are not asking you. Question is that what is the fault of the court? You are now saying that the court has committed a mistake in passing the order because the necessary parties are not there on record and the order was passed which ultimately affects you. So the question is that all these things should have been brought to the notice of the court that these are the persons
It is
who
the
are
duty
likely
of
to be.
registry, my lord. Registry has to put forth these things before the court.
How
It is
can the
duty of
registry come to know, sir?
Registry of convocation.
It is none of the duty of the registry. How can they know?
How can they know? Just that is, please answer.
We are the party in the court in the earlier litigation basing on which we are going to be appointed. And that order
is
again challenged before the court tribunal. And if the tribunal is challenged, the tribunal
These
also
rules which you are referring to is in reference to the parties who are already on record. On those aspects, the court must ensure. Rule
we are
11,
already
Rule 30.
on the record because they have already impeded as a party.
Where? Where is
As
that?
per the order, my lord.
Where is that?
That order is there. Page number 104 and page number 106, 116.
10?
In 104, my serial number is 11, NVK ready. 104. Serial number 11, NVK ready.
NVK ready.
My lord, I myself is the petitioner.
Page number 104.
104. Acha.
Party number, respondent number 11.
11.
So, no, you are right. This order was dated 4/1/2024.
My lord.
Which you are challenging now, along with that RA.
RA. That is order dated February 2013.
Oh, you have been made a party there.
Yes.
As 11.
My lord.
That is your valid point only thing.
My lord.
So having made a party, you have not been issued notice. That is there.
Just a minute. Please come to page number 105.
My lord.
105 is the impugned order.
My lord.
In 105, your name does not find place.
Why not? It is not because the amendment has made a letter on that is 17 to 24, man. 13 to 24, page 116.
Amendment for what?
For implement, the name of the party has not been reflected. That's why they have.
Where is that, Learning Counsel?
116 page.
Page 116, let us see.
This array has been filed by the applicant virtually praying for correction of a typographical error crept in the final order dated 4/1/2024 in OA number 49/2019 in as much as inserting the names of the respondents in the cause title. And prayer portion stated in the constituted way on a perusal of record, it is seen that through amendment the applicant inserted one prayer in the way has also added private respondent, but since the amendment was not carried out in the manner it should have been done, the same inadvertently could not be reflected in the final order of the way. Therefore, since the prayer of the applicant in this petition is formal in nature and would not change any nature and character of the final order, we find the prayer of this petition is justifiable according the array is disposed of in circulation by inserting the private respondent.
Order is passed. His name has been inserted.
Well,
And to make the order proper.
well,
All right.
All right. This petition has been filed by the petitioner in Vinay Kumar Reddy with the prayer was the ex parte order dated 4/1/2024 passed in OA number that's one of the land state
Central.
Central Administrative Tribunal in OA number 216/00491 of 2019 and order dated 13/2/2024 in RA number P of 2024 by Annexure
7.
7. So also the so-called notice issued by the opposite party number. Here's the opposite party.
Senior divisional director, my lord. Senior divisional. Open 4.
Opposite party number 4, dated 17 February to the petitioner. The learned counsel for the petitioner submits that the input order dated 4/1/2024 indicates that one S.K.Sahoo, he is in this petition is opposite party number S.K.Sahoo,
6.
opposite party number 6 by the original application with the following prayer for that prayer that is available in page number 106 in paragraph number 1 in that prayer. So in the said original application there were 5 opposite party respondents and the petitioner was not the respondent in the original application. The original application was disposed of as per order dated 4/1/2024 and the learning tribunal has been pleased to allow the original application and came to hold that the action of the respondents in taking into consideration ACRS public working report of 2015-16, 2016-17 and 2017 and 18 and rejecting the case of the applicant illegal and divorce of rules of the law. And accordingly, the respondents were directed to re-evaluate the case of the applicants for the said selection, taking into account the result of the written test published on 21/6/2010 and taking his SCRS public working report of 2007-08, 2008-09, and 2009-010, and thereafter communicated with the kitchen of the said consideration by way of passing a speaking and raising order to be communicated to the applicant within the period of 60 days from the date of receipt of the copy of the order number 114 and 115, 114. Let us start with about 5 lines from the bottom. The land counsel for the petitioner submits that after the original application was disposed of as per order dated, improved order dated 4/1/2022, RA number 260/003 of 2024 was filed by the applicant for inserting the names of some of the respondents, inter alia with some with prior portion in the consolidated volume. And the petitioner and the order was passed on 13/2/2024, wherein it was held that the prayer of the applicant is formal in nature and would not change the nature and character of the final order. And accordingly, the prayer was accepted and the RA was disposed of by inserting the private respondent in the post-edit and prayer in the final order. Stop. Land counsel for the petition submits that in the RA, the prayer was made to mention the name of the petitioner as one of the respondent, which was accepted, but the respondent has never been noticed in the original application, nor he was given an opportunity of hearing. It is submitted that through the appointment letter so in the appointment letter, it is mentioned that the appointment of the petitioner is subject to the result of OA number 260/00491 of 2019, pending before the Central Administrative Tribunal Cuttack bench. But in the fairness of things, the same should have been brought to the notice of the court by the opposite party number. Railway kete number opposite party opposite party number 2 to 5, which has not been done, and even the applicant or in the original application is the opposite party number 6 in the
Lordship reflect 1 to 4, not 2 to 4. 1 to 4. JMH 1 to 4. General manager also coming especially the part
1
of
to
the
5
I can senior
divisionary electrical.
electrical engineer.
that is in our case.
1 to 5. Who is now the opposite party number 6 has also not taken steps during the pendency of the original application, but the step was taken only after the disposal of the original application by filing RA. Issue notice on the question of admission indicating that the disposed of or the stage of admission, the Union of India accepts notice the sponsor party present and accepts notice on behalf of opposite parties number 1 to 5. That extra copies of the resolution be served on them. So far as the private opposite parties number 6 to 11 decisions for instance of notice we filed within 1 week, and the matter will be listed with after in the new year that starting to not practically any file in time. Interim application, an application for stay of operation of expiry order dated 1 the operation of one and the
Item 7.
May I please, your lordship? Ma'am, this case is covered by your lordship's order. The forwarding is number.
you have made any
50 orders
Your lordship was pleased to call for the counter millets. Yes.
no, the same order
Well, sir.
यहाँ order
अब उसने correction कर दे दो correction कर दे yes. Ma'am, it's a case. Yes. Your lordship was pleased to call for the counter millet. Only one request, one prayer, your lordship. But similar matter wherein your lordship was pleased to call for the counter has been listed in the at serial number 54 millets.
we just say this along this one.
Yes.
We are not reaching 54 today.
Yes, sir.
So whenever 54 will be taken up, this matter will also be taken up.
Yes.
We are just passing the order.
And the
Necessary correction. Annexure number. The annexure
Remunerator କୋଉଠି ରହୁଛି ତାଙ୍କର ଯୋଉ
Item 8.
Item 8 is a covered matter, my lords, covered by your lordship's order. Yes, my lords.
any correction should be carried out.
Yes, I have corrected copy.
Item 9.
Disposed of matter.
Yes, my lords.
Item 9.
Number 9 and 18. That is also covered by your lordship's order.
Please pass on that.
No,
That,
last time we had asked for certain things
Only correction has to.
with regard to the S order.
Right.
So we pass the order.
Your lordship passed the order, no? 5 बार है. Only annexure objection test number का change है. चेंज खाली हो annexure 5
Associate to only gold reading.
हाँ कर देते.
Right, and this is 9 and 18.
9 and 8. 9 and 18 पे दीटा correction देबे.
Footer 9 रे footer रहिबो और footer 18 रे footer रहिबो. ये जो annexure number होरा
दे दे कर दो. Dispose of dispose.
Item 10. In similar cases, your lordship has passed the order, my lord. Annexure 4, my lord. Annexure 4 is annexure. That is annexure 4. But para 3 रे सेठी
annexure 4
my lord. Para 3 रे सेटा annexure 3 हवा. Para 3 ର last portion रे सेटा मु राउंड कर दीची.
दुटारे समान हो ता ऊपर सीरियल नंबर उठा लिखि दो
सब
10 11 1 सब चेंज हो
किछि
आइटम नंबर ए तादे ए चेंज हम गोल बुले देकी
ସବୁ ସବୁର annexure 4 ହଉଛି representation same ଅଛି but para 3 ରେ
serial number ଉପରେ କୋଉ ଗୁଡାକରେ ପୁରା କିଛି ଚେଞ୍ଜ ହବନି ସେଟା ରହିବ ଆଉ ଯୋଉଥିରେ ଚେଞ୍ଜ ହବ ସେଇ ସିରିୟଲ ନମ୍ବରଟା ଲେଖିବ ଆଉ ଯୋଉଟା ଚେଞ୍ଜ ହବ ବହୁତ ଦେଇକି ତାକୁ pencil ବା କଲମରେ ଲେଖ.
Oh, you want a change in every
ହଁ
read petition? Oh, then accordingly you mention it.
para 3 ର खाली last
Say
portion
yeah. And
Single
your
copy.
item number 14 is also the same.
same 10 11
10, 11, 12, 13, 14.
13 not
13 not
14
14.
में.
नहीं
अच्छा.
10 11 12 and 14 item 13
My representation on the annexure 3 pending before the OP number 2, my lord.
आपने order pass ହେଇଛି କି? नहीं. Annexure 3
item 15
This matter, let's see. Demand notice was sent to my client lordships on
What notice was sent?
uh,
Possession notice.
possession notice. Prior to that possession notice, statutory notice reply to my legal notice was sent on 7/11/2023. That is at page 18 lordship, starting page 19, para 4.
So 34 notice has been issued that is under challenge.
That is under challenge. Lordship, before that, I would like to say, my lord, this 13-4 notice does not contemplate in my case. For the purpose, Lordship, Lordship, kindly see the annexure. Page 19, Lordship, para 4, Lordship. That as per direction of this honorable court, it is to your kind notice that, Lordship, I am reading para 4, Lordship.
Yes, sir.
Notice that you have to pay 2,10,000 amount for regularization of the NPA housing loan account and to go on paying the EMI regularly. It is also to your kind information that housing loan account is not coming under any OTS scheme of the bank for which the same cannot be settled under OTS. However, if you want to close the loan account, then you have to pay the total outstanding this month. Immediately, Lordship, 7/11/2023, they demanded to pay 2,10,000. Now, Lordships, page 17, Lordships, on 19/12/23, I paid 2,50,000. Page 17, Lordship. They have to only restructure the account. Instead of restructuring the account, they did not accept this money they have received. They proceeded with the notice of 13.
Right now, your lordship, the balance is more than 18 lakhs.
Taken care of by DRT. Let's go. Yes, next.
My name may be reflected in the. I am the caveator. Yes, my
You
lord.
are appealing for the issue back, right?
Yes, my lord. Oblige.
Meantime, Lordship, they should not proceed till I file.
Up to by tomorrow. Yes,
item 16
My lord, item number 16 is also covered matter, my lords. I am corrected.
Any change you?
Yes, my lord, I have.
In that.
item 17
May it please your lords. The petitioner is the All Odisha Judicial Typist Association. Their prayer is for implementation of the City Commission report. They had submitted a memorandum of appeal before this honorable before the High Court that has been rejected by order dated. Your lordship may kindly turn to page 77. That has been rejected. All other in respect to clerks and stenographers that has been implemented, these are typists.
Case 77 is the rejection order.
It says in that.
That is regarding all judicial officers, subordinate staff, City Commission report, and they say that
No, you kindly point out that, but
my lord, your lordship may kindly turn to page 24. Second part I, 1. The
24
तले अधा 50% तले half ro tale. 1. The High Courts on judicial administrative side will ensure implementation of the recommendation of the City Commission within a reasonable period of 1 year. The High Court shall permit writ petitions or applications that may be filed by the individuals or staff association representing the various members of the staff.
City Council court ରହିଛି ମାନେ ବନ୍ଧୁ
That is not there.
typist ମାନଙ୍କ ପାଇଁ ବା staff ମାନଙ୍କ ପାଇଁ
ନାଇଁ ଆମେ
ସେଇଟା-
ଏଠି ଦେଲା ପରେ ହାଇକୋର୍ଟ ଡିସାଇଡ୍ କରିବେ
ନାଇଁ
my lord, your lordship, yes.
ଆପଣ କେସଟା ଯାହା ସେଟା ଆପଣ କହିବେ ନା ଯେ ସେଠି କମିଶନ
ଆମ-
has mandated for this benefit to you which has not been granted.
My
So
lord,
benefit ଟା କଣ?
your lordship may kindly turn to our prayer.
So read petition
ହଁ grade 1
ଦିଆଯାଉ ବୋଲି
ଆଜ୍ଞା level 1
କୋଉଠି
level
ଅଛି
2
ସେଇଟା?
level 3 କୋର୍ଟ ହେଇଯାଇଛି
ସେଠି କମିଶନ ଟା କୋଉଠି ଅଛି?
City Commission has fixed that all the grievances are to be decided by the Honorable High Courts.
No.
ଆପଣ ଯେମିତି କହୁଛନ୍ତି ସେମାନେ typist କହିବେ ଆମକୁ ଟିକେ ଚନ୍ଦ୍ରକୁ ନେଇକି ଯାଆ
ନାଇଁ typist and typist
ସେଟା ଦେଖିବେ ନା
ଆପଣ ଏଣ୍ଟାଇଟଲମେଣ୍ଟ ଟା କଣ ପାଇଁ ସେଠି କମିଶନ ଗୋଟେ ଦେଇଛନ୍ତି ଯୋଉଟା କି ହାଇକୋର୍ଟ କନସିଡର କରିବା କଥା ସେଇଟା କାହିଁକି? ଟାଇମ ସ୍କେଲ ପ୍ରମୋସନ କହିଛନ୍ତି, ରିଡେଜିଗ୍ନେସନ କହିଛନ୍ତି, କଣ କହିଛନ୍ତି?
can pick up this matter tomorrow.
well,
This matter.
chalo.
Item 18. Item 19. Item 20.
119. My lord, here in this case, petitioner before my lord is a owner of a joint family court. And the property, one of the courts,
What is your prayer in this expedition?
my lord, my only limited prayer for quashing up annex that notice issued under section 14 to the issued by the collector for taking delivery position of the titular.
So you are having a forum, alternative forum to assail that. Okay, so we are disposing of, you avail that forum. Yes, surface area section 14 is under challenge, so the alternative forum we have. Yes, ma'am.
Item 20.
Legal assets. Annexure 7, page 81. The order passed by the Central Tribunal is under challenge lordship. The order stated 2/12/24 lordship, where the termination order of the present petition has been confirmed in dismissing the OA lordship. 2/12 or 7/12? My lord, 2/12/24 lordship, page 81, annexure 7. My lord. The present petition was the applicant before the.
Number 2.
My lord. Yes, your lordship. The challenging the quashment of the termination order dated 8 March 2017. My- My lord.
Now, to the operative part of the improved order.
My lords.
What was held by the planning tribunal. Your original application was dismissed.
Yes, Your Lordship.
Right.
My lords.
Now, we come to the paragraph number 16.
Yes, Your Lord.
Number 96 and internal page is 16.
My lord.
It's traced from paragraph number 6.
My lords. Two grounds are there, Your Lordship. Yes, the subsequent ground, persistent Lordship. On a microscopic examination of the aforesaid order, it is clear that the language of the termination letter does not cast any aspersions or doubt on the conduct and character of the probationer applicant. In the pleadings, it is not the case of the applicant that the termination was due to lack of his efficiency or integrity or unsuitability. From the counter, it is also not forthcoming that termination was due to any of the aforesaid reasons. Lordship, on two grounds, read it, sir. Sir, my lord. Paragraph 17. One of the judicially evolved tests to determine whether in substance an order of termination is punitive is to be seen whether prior to the termination there was a full-scale formal inquiry into allegations involving moral turpitude or misconduct which culminated in a finding of guilt. If all three factors are present, the termination is to be held as punitive irrespective of the forms of the termination order. Conversely, if any one of the three factors is missing, the termination cannot be said to be stigmatic. Thus, going by the order of the termination and the pleadings, we do not find any substance on the stand of the applicant that his order of termination is a stigmatic one. In the result, we find no merit in the way which is dismissed accordingly by leaving the parties to bear their own part. But on two grounds, Your Lordship, the way was filed. First is the probation period was 2 years, and on completion of 2 years, the authority has not extended it nor given any remarks of other dissatisfaction. And after 4 years of completion of a probation period, Your Lordship, the termination order has been passed. Though the in view of the Rule 5 of the CCS Temporary Service Rule 1965, the ground of the petitioner before the Tribunal was whether the Rule 5 of the CCS Temporary Service Rule 1965 is applicable to the present petitioner or not. That was one question which has been dealt with by the Tribunal, Lordship, in my lords. Yes, the respondent filed the counter opposing and contesting the case of the applicant. The main thrust of argument of the respondent is that 6 posts of the LDC were notified by respondent number 2. Applicant having been selected was appointed provisionally. He was kept under 2 years probation from the date of his appointment. One of the aspiring candidate, that is Sri Mithun EP, who had appeared at the written state filed OA number 18 of 48 of 2015 before the CAT NR Quorum bench to set aside the entire selection process and the appointments made by CPCRI. Besides, the Chief Vigilance Commission, Government of India, also forwarded some complaint to ICAI directing to inquire the matter and take appropriate action. In view of these reasons, the clearance of probation was not considered by the competent authority, and the confirmation of a probationer after completion of period of probation is not automatic but is to be followed by the formal orders. Till a specific order of the confirmation satisfactory completion of probation is issued, a probationer shall be deemed to have been continued on probation and his period of probation remains in force till then. Mere continuing of an employee beyond the initial period of probation cannot give him right to be observed in the regular service or made permanent. Since after inquiry it was established that irregularities have been committed in appointment of lower division clerks at a CPCRI, after analyzing this investigation report, as per rule, the service of the applicant was terminated, which warrants no interference by this tribunal.
So to meet this point, Your Lordship, kindly have a glance on page 72. During pendency of the OA, Lordship, my probation period has already been cleared by the authorities on satisfactory, and my job have been regularized, Your Lordship. 72, Your Lordship. Page 72, the read application. On 3/11/2023, on the recommendations of the DPC for probation clearance and a confirmation held on 3/11/2023, Director ICAR CPCRI Kharagad has been pleased to declare that the following LDCs as its institutions as institute has completed their probation period satisfactorily and confirm in the post of LDC with effect from the date mentioned against each. The clearance of probation and confirmation in the post of LDC is subject to the outcome of OA filed by them in various benches of the Honorable CAT shown under remarks. Here serial number 2 is the present petitioner Lordship, Satyavata Maharana. Is the date of completion of a probation period, it was 1/5/15 and the date of confirmation is 2/5/15.
No, that is not important. Important is the last line that you read.
Yes,
LDC is
Lordship.
subject to the outcome of OAs filed
Yes,
by them
my lords.
in various benches of the CAT.
Yes, Lordship. That
so
is there. Subject to
this
result of OA.
As it appears from the order of the authority,
My lords.
this is a termination simpliciter,
My lords.
not basing on any stigma.
Yes.
That is how no inquiry has been conducted. No
Yes.
disciplinary authority has been
Yes.
and interfered. So, what is the result of the CAT? CAT result कौन हला?
My lords. Yes, this way. My lords. Yes, Lordship. 154, 260/154/17.
Subject to this.
The present impugned order is the passed in that way.
No,
Lordship.
this you have not filed.
Yes.
You have filed.
Yes,
So
Lordship.
your appointment was subject to the result of this way.
My lords. My
Right.
confirmation, not appointment, Lordship. My appointment was
Yes, that is
selected in due
you were
procedure.
in probation subject
Yes.
to your confirmation.
My lords.
Confirmation was subject to the result of the way.
My lords.
So,
But the sole ground of the termination, Lordship.
No, but you are not telling the correct thing probably.
No,
You have challenged your termination before in the OA,
Yes, Lordship.
whereas the order that has been passed confirming your probation period
My lords.
is in respect to the OAs filed,
Including this one, Lordship.
not including.
48 of
This
15,
you have
page
filed
87.
subsequent to that.
No, my lords. During pendency of my OA, that means OA number
No,
2.
your OA is against the termination.
Yes,
So
Lordship.
it is only after your termination that you have filed this OA.
My lords.
So how could it be the one that has been referred in your confirmation? That has not come then.
No, my lords. Confirmation after that, Lordship. During pendency of OA, this
So
confirmation.
before the termination, you had come to the court.
No, my lords. After termination order, Lordship, challenging that termination, 2017 order, the petitioner before the tribunal, filing this OA, Lordship, OA number 260/150 of 17. And during in that OA, Lordship, under Annex 2 interim order passed, I am continuing. And during the pendency of this OA, Lordship, the confirmation order has been passed. And the sole ground of the OPJ, Lordship, so far termination is concerned, though applicability of Rule 5, that my probation order has not been clear.
Challenging which order you had come to, you have filed the OA?
Termination order?
Where is that? Which termination order?
Yes, Lordship. Termination order is at page 54, Lordship. My lords. 8th March 17.
54. This is termination simpliciter.
My
so
lord.
After this order,
My lords.
they have confirmed you.
Yes,
While the OA was pending, you had challenged this order in OA.
My lords.
So during the pendency of that, this
confirmation order has been passed.
Once again.
72, Lordship, page 72.
Who has issued this after termination? How they have issued this? यार authenticated ये copy कहाँ काहाकु के issue करছে এটা? This is the office order.
Yes, Your Lordship.
Sure.
Yes, Your Lordship.
Who has issued this? Who is the authority?
The administrative officer.
No, signature वाला proper दियंतु record. This is neither signed by anybody nor an initial is there. Where is that? Who has signed it? To whom it has been issued?
How it can be passed?
Impossible.
Somebody has been
Terminated.
and his matter is subjugated before the Central Administrative
Tribunal.
During that period, how
They will confirm.
It appears that this document is a doubtful feature. This
Let
page
them-
number 72.
Let them take opinion, sir.
Who is
Keep
appealing for this?
Madam, I am there one to the opposite parties.
For this car central plantation.
That's that ICR that I am happy.
You are there.
Madam.
Kindly confirm.
So confirm this that
Madam.
office order is genuine or not.
Madam.
Okay.
The Lordship may class para 9, page 89. The reason assigned. The original
No,
OA
we
file.
will be going there. That's a different.
Each case is based mainly on this page 7.
Yes.
We want that it is authentic document.
Madam.
Correct?
Yes.
Look on. This writ petition has been filed by the petitioner Satyavata Maharana. With a prayer set aside the order dated 2/12/2024 passed by the Central Administrative Tribunal Cutter in OA number 260/0000154 of 2017 under Annexure 7 and also was the termination order passed by the opposite party number 2 on 8th March 2007. As for the termination order dated under Annexure AY4 to the original application. During course of argument, the Grand Counsel for the petitioner drew the attention of this court to
Office order.
Annexure 5, which is the original application, in which a document has been annexed to, which is stated to be the office order
Dated.
dated 3/11/2023, issued by the administrative officer of ICAR Central Plantation Crop Research Institute, Kasaragod, code 671124, Kerala, page 70. And it has been mentioned therein that on the recommendation of the DPC for probation clearance and confirmation held on 3/11/2023, the director from ICAR-CPCRI from Kasaragod has been pleased to declare inter alia the petitioner to have successfully completed the probation period and confirmed in the post of LDC with effect from the date mentioned, and the clearance of the probation and confirmation in the post of LDC will be subject to the outcome of the original application filed by the petitioners in way number 260/154 of 2017, filed before the Central Administrative Tribunal, Cutter bench. The Learning Council for the state took some time to obtain instruction about the authenticity of this particular document. That is the office order dated 3/11/2023 and filed an affidavit to that effect by a responsible officer. All right. Lest this matter duly commencing from such and such date. Copy of the order be handed
So
over.
this
Silent-
document was not before you at the time of filing of the OA.
Yes,
So
sir.
it came in between.
Yes.
Before the
Accordingly,
passing of the
I
order.
filed the additional affidavit with all these documents
All-
for the OA.
all.
The IA lordship, I am in
My
service of
name may be
lordship.
recorded. I'm for opposite party. I'm for opposite party.
Opposite party number
1, 2, 3.
1, 2, 3.
opposite party number 1. You are appearing
ICR.
the order copy will be given to you.
Yes.
After the
2nd week of January.
And file an IA lordship. I am in job lordship in view of the order passed in Annex 2 lordship, page 50. Lordship, someone carry the lordship. My job is there, lordship. I mean, lordship interim order there. In view of the interim order, I am continuing a lordship. Annex 2 is the order lordship.
This is taken up for the first time.
Yes, the in all along in the OA lordship.
Once we are doubting something, we cannot pass anything.
Lordship, my job will be
clear that a prima facie case is made out, and that to basis on the clear documents. On the basis of any kind of forged document, we cannot pass any interim order.
not a full document lordship. That is
why we have asked.
till then lordship में status quo भी maintain. Lordship में still then status quo भी maintain.
Item 21.
मतलब still then status में चाकरीटा पळेबो लordship. लordship में कौन से
Item 21.
Yes, please, my lord. What else?
Counsel for the you are supposed to file the surrender certificate. You have been granted interim bail.
My lord.
So what is your instruction? Have you
I have
filed the interim bail and you have surrendered after availing the same or not?
no instruction.
You have no instruction. The current counsel you should have said so before the while seeking for adjournment. The current counsel for the petitioner, appellant person, submits that no, this case was listed today as the surrender certificate as per the order dated 27/8/2024 has not been filed by the London Council for the appellant. The London Council for the appellant submitted that he is not aware whether the appellant has availed the interim bail period as per the order dated 27/8/2024 passed in this case number 80 of 2016 or not. In view of such submission, that instruction be obtained from the London Trial Court as to whether the petitioner availed the interim bail order, and if so, whether he surrendered at right time or not. For such purpose, the file be placed before the London Registered Judicial shall make necessary communication with the London Trial Court, and the report should be furnished by such and such date, and matter will be placed in this court on such and such date. Yes, ma'am.
Obliged.
Item 22.
Mr. Ponda,
None.
Item 23.
May I please, your lordship? Well, last occasion, your lordship directed to the State Council for taking instruction regarding
Criminal
antecedent.
accident.
Yes.
कौन अच्छी कहता
No. It is found that as accused person is not involved in any other case except this case.
Is it your first time or earlier your bail application has been rejected?
No, my lord. The first time.
You have never been granted interim bail?
No, my lord.
What is the date of custody?
Custody, my lord, 8/11/13.
8/11/2013.
My lord.
8 years, 8 months. 8 is last custody. Flag D. Flag D. Flag D.
Custody certificate that detective.
यानी
25/9/2016
ओहो सेप्टेम्बर
ସେପ୍ଟେମ୍ବରରେ ଆପଣଙ୍କର ହଉଛି 8 ବର୍ଷ 8 ମାସ 28 ଦିନ। ଆପଣ ଯାଇଛନ୍ତି
Parole.
actual custody 4 years
ଡେଟଟା କହୁଛନ୍ତି
ନା actual
ଠିକ ନୁହେଁ।
ନା ନା ନା
Custody on under trial 17/5/2016.
ହଁ
ନାଇଁ ନାଇଁ
ଏଟା ଠିକ ନୁହେଁ।
ସରି
Bas.
ରଙ୍ଗ ଡେଟ୍ ମୁଁ କହିଲି।
ଦାଶରଥୀ ପ୍ରଧାନ ଦାଶୀ alias ଦାଶରଥୀ ପ୍ରଧାନ ନାଁରେ ଚାର୍ଜସିଟ୍ ସବମିଟ୍ ହେଇଥିଲା ଆବସେଣ୍ଟ ହିସାବରେ and ଚାର୍ଜସିଟ୍ ସବମିଟ୍ ହେଲା 2/7/2014 ରେ। ଆପଣ କଷ୍ଟଡି କେମିତି ପଳେଇଲେ 2013
ନା ନା
ସରି
type of statement
ରଙ୍ଗ ଡେଟ୍ ଟା କହିଲି।
ଆମର ତ ଇଏ ହେଇନାହିଁ 7 years
ଆପଣଙ୍କର 8 ବର୍ଷ ହଉଛି 8 ବର୍ଷ 8 ମାସ
28 ଦିନ।
maybe that it is the order ଏଟା ହଉଛି 25 ନ ଆଉ
28 ଦିନ ଅଛି।
10 ମାସ ବା 11 ମାସ
My lord,
8 years 11 months. So what is the conviction and
302
302
at 25/27 Arms Act.
private law
My lord.
Arms Act ଅଛି ଆଙ୍କ ନାଁରେ antecedent
Antecedent ନାହିଁ antecedent.
ଆଣିଲେ
Report କର।
So what is the case what is the prosecution case come to paragraph number 2
the case of prosecution that the occurrence was taken place in the midnight of 7/11/2013 at Golahandi Nuasai of Kishore Chandrapur under the Daspala PS. It was alleged by the informant named Kulamani Muduli, who is none other than the husband of the deceased Nibasi Muduli, that on the occurrence day evening he went to his paddy land to guard the paddy, and in the midnight his elder brother named Pavitra Muduli along with others came to him and informed that accused Dasarathi Pradhana killed his wife by opening fire from his country-made gun and ran away from the village. He immediately returned to the house and found the dead body of his wife laying inside the house, and his daughter named Gitanjali Muduli and his son Munna Muduli were crying. He came to know from his daughter Gitanjali that in that night at about 8:30 p.m. the accused Dasarathi Pradhan came to his house and inquired about him, and after some time again he returned and picked up quarrel with Nibasi and opened fire from a country-made gun, for which the said Nibasi died at the spot. After hearing the incident,
there are eyewitnesses to the
Yes.
Who are the eyewitnesses?
PW
3 and 10.
PW3 and PW10
10.
3 not eyewitness, but 10 is the eyewitness.
internet
ନା ତିନିଟା ସେ କହିଲା ମୁଁ ଆସି ପଦାର ଦେଖିଲି ଯେ
PW10 ହଉଛି eyewitness
ଡଟର ଅଫ ଦ ଡିସିଡ୍
okay
ଡଟର ଅଫ ଦ ଡିସିଡ୍ ମ୍ୟାନ୍
and who is the doctor who conducted PA
PW
15.
15
Man.
we come to PW15 part. Let us see what type of injury has punctured wound is there. State is due to concert injury. Okay, now we come to the evidence of PW10.
PW10 page 79. I know all the accused persons standing inside the dock. The deceased Nibasi Muduli is my mother. The informant is my father. The village road is on the western side of our house. Our house consists
of 3 rooms. One room adjoining to village road we used to cow shed. The next room is used as bedroom and the next room was used as kitchen. There is a door in between the cow shed and bedroom. The width of the cow shed is about 10 cubit. Para 2 on 7/11/13 at about 6 p.m. in the evening, my mother went to
My father went.
my father went to the paddy field to guard paddy cultivated on our land. On the same day, at about 8 to 8:30 p.m. in the night, accused Dasa came to our house and knocked the door. I opened the door and asked the accused Dasa as to why he was knocking the door. Then he asked about my father. I told him that my father had been to the paddy field to guard paddy. I asked him to come in the morning if he had any work with my father. After 5 minutes, accused Dasa came to our house and asked about my father. My mother asked the accused as to why he was searched for my father and told him to come in the morning. Then the accused returned back to his house. At about 12 o'clock in the midnight, the accused came to our house and teased the bullocks tied in our cow shed. Hearing sound, when my mother and myself got up and opened the door, suddenly accused Dasa fired from his gun, which he was holding. As a result, which my mother sustained bullet injury in her belly due to firing by Dasa. The bullet hit my mother, came from the gun the accused was holding.
କହିବାର ଅଛି consult କରିକିନି ବେବିଟାକୁ ମାରିଛ. What is your submission? You are in custody of course 8 years and 11 months. So
In the cross examination, she admitted, my lord, there was a previous dispute between
motive ଅଛି. Means motive is strong.
quarrel with his father, my lord.
You are targeting father.
ଦୁଇଥର ହଉଛି ଯାଇଛି ମାନେ ତା ବାପାକୁ ଖୋଜିବା ପାଇଁ. ବାପାକୁ ଖୋଜିଲା ବେଳେ ବାପାକୁ ପାଇନି. ସେଇ ସମୟରେ ଏଇ ଯୋଉ my lord kindly see page 99 the result of examination of the state forensic laboratory. ସେ ଯୋଉ page 99 result of the examination. One shot that is marked J. Column 3, my lord. One shot marked J, no blood. Again, marked J. My lord. One shot, no blood, my lord. And doctor opined, my lord. Page 99. State Forensic Science Laboratory, Russell Group.
result of the
exam.
Ultimate single barrel muzzle loading gun having so and so. It exploded.
Our sample earth, no blood, and one shot. जोटाକୁ ସେ ରିସିଜ୍ ହେଇଥିଲା, that is no blood, my lord.
Firearm ରେ କେମିତି ଲାଗିବ?
The pellet siege
pellet ଟା କହିଛି ନା firearm ଟା କହିଛି?
ନା one shot.
ହଁ
ଗୋଲଟା ପଶିକି ବାହାରି ଗଲା ଆଉ
ସେ ଇଏ ଗୁଡାକ 12
ବାହାରି ପଳେଇଲା
ବାହାରିକି ପଳେଇବା 12
ପରେ ଆଉ there is no blood, then rupture will come and blood will be received.
12 muzzle loading para.
Doctor also PW 15, my lord, doctor. In the cross examination, it is admitted.
Postmortem report.
One dissection, one pellet was recovered. As there was no exit injury.
Page 88.
Size of punctured hole.
Evidence of the doctor, my lord, in his cross examination. In his cross examination, my lord, doctor stated, my lord, I handed over the pellet to police except the gunshot injury.
ତାପରେ ଗଲା ଏଠିକି
ହୁଁ।
ଆପଣ ଦେଖିଲେ ଯୋଉ
Forensic.
ଏକ୍ସାମିନ୍ କରିବା ପାଇଁ
ସେଇଟା no blood ବୋଲି ସେଥିରେ ଆସିଥିଲା।
ପ୍ୟାଲେଟ୍ ଭିତରୁ ଆସିଛି।
ଏକ୍ସିବିଟ୍ ସେଟା କେତେ ନମ୍ବର ହେଇଛି?
J.
J. Is the fired iron shot of a muzzle loading gun once to wait definite opinion cannot be given as to the firing of to fire machine. But how do you, so let us say that there is some kind of not sureness. How do you overcome the evidence of that girl who had seen her mother being fired by the youth in the house? You came twice and asked for the father. Father was not available, and then you mother opened the door and you fired gunshot at the.
The 27 my lord, it is seized from the co-accused my lord, not from the seized from the petitioner my lord.
No, she that recovery na she olga kata, but you are the offer is not there. The somebody else was in your company. So jab ye korichi ba fire korichi, it is not necessary that it should be recovered from his possession so that complicity will be proved. Otherwise, if it is recovered from somebody else, your complicity will not be. One girl has seen how the mother was fired by you.
My lord, the
He was
eyewitness my
present
lord
since
is the
22 years.
interested witness my lord, as because my lord, there is a previous enmity.
At the time of final hearing, and I think
And inside near about 9 years my lord, and no antecedent.
is ready. We are adding it to the hearing list. In the January or March will be there. Are the learning council are the learning council for the petitioner and council for the state. It appears that the petitioner in judicial custody for 8 years 11 months. So the learning council for the state submitted that there is no criminal antecedent as per the report received by him. It is reported they gave a copy of it. But we find that in view of the evidence of the eyewitness PW10, who is known as then the daughter of the deceased Nivasi Duli, and stated how the deceased fired gunshot, how the apparent fired gunshot at the deceased, and the evidence of the doctor that at the PW15 to stated that cause of death of the deceased was due to gunshot injury, the vital organ of the deceased. We are not inclined to release the petitioner on bail. However, taking into account his period of detention in judicial custody, and since the paper book has already been prepared, the matter be added to the hearing list in the third week of January 2025.
Item number 24.
Yes, sir.
Oblig.
Item 24.
The 24 by 12/11 order lordship directed to state criminal antecedent. 2011, sorry. 2011. Last part. I pray some time to obtain that custody certificate.
After 2 bar
Para 7.
time limit.
We directed that the deposition copies, prisoner's petition, judgment copy, and evidence copies of all the witnesses, so and so, to be supplied.
Party.
Receive that.
No.
किए मना करा कि आपण ऑर्डर टा हला पेन ड्राइव रे आपण नहीं जिवे नो माने कोन आपण दिया ही था आपण
And Mr. Padi, he has not taken. He want to requested me to urgent this case. So,
or like mention is made on behalf of so and so for adjournment after year for them vacation maybe holidays Xmas holidays kon
Item 25.
what is it?
And then
Wait, just a minute.
I'll take it.
Yes, Mr. State Counsel.
My lord. That affidavit filed today.
The
copy the filing also made. Here is the question, my lord. In the same name, appellant's name and father, there are 2 persons.
No.
In the same village.
So you mean to say that so far as
So the antecedent which was intimated by the IO in respect to the person who is, he is not the present appellant here. This is the affidavit.
Paragraph
Para 2 mechanical glance. In pursuance to the above direction, the deponent verified the record and found that in the same village as that of the appellant, that is the Kanpada, Mothosai, there are 2 persons, namely Pradeep Malik. Coincidentally, the father name of both the Pradeep Malik is Panchu alias Panchanan Malik. Therefore, when the deponent verified from the official portal of the state, that is Crime and Criminal Tracking Network and System, in name of Pradeep Malik, so son of Panchanan Malik, 5 cases were reflected. Therefore, the deponent submitted the verification report by letter dated 10/8/2024, showing 5 cases against the Pradeep Malik, son of Panchanan Malik. Copy of such answers.
So that means there is no CA against
Present appellant.
And as for that order, it indicates that he is in judicial custody since 24/1/2016. And what is this case, Mr. Abdullah?
appellant
You have been found guilty under section
376(2)(I).
Yeah.
And section 4 of the POCSO Act.
Who is the victim?
PW1.
Victim is PW1.
PW1 is the victim. Doctor is?
Pardon?
Doctor.
Doctor is PW10, man.
You come to the evidence of PW1. Or age is 12 years when she deposed.